other courts are closed down and that other litigants are not allowed to have their day in the market. I'm fair-minded enough to know that a system that does not allow other litigants to have their day in the court just because of one litigant cannot be said to be fair. I'm a human rights activist and constitutional lawyer. I know that my conscience also as a Christian does not agree with that. But there are areas in the new practice directions that I correct with. In other words, I do not mind if they move the venue to another place that does not disturb other litigants and clients and witnesses and all that. But I'm worried about one provision that screens off journalists, the media, the fourth estate of the realm under section 22 of the Constitution. Because if you stifle information, the wrong information can emanate from the rumor mill, and that is a more dangerous issue. The Supreme Court says so, and I think that was in the case of Adesanya versus President of the Senate. If you stifle information, then the rumor mill will become very active and things will begin to germinate. We have a proverb in my home, in my language. I'm from Iyukwe, near Agenebode, East Local Government area of Edo State. The proverb is, Ono ayoela zavuyuko, lo hazo mo agule. What does it mean? He who was not present when a fat he-goat was butchered will argue later that a fetus must have been removed from his tummy after it had a big tummy. In other words, seeing is believing. You don't hide information. So when you prevent the media from covering a trial, then it may lead to generation within the rumor mill of things that never happened, which again jeopardizes the fair trial of an accused person, even of the prosecutor and even of the judiciary itself. In terms of witnesses attending, I have no problem with witnesses being screened off. That is good to safeguard the interests of the witnesses and the fact that you refer to them as A or B instead of by their names. That safeguards them. That is a very wise decision. Safeguard witnesses, screen them off. Or if you want to use Zoom, fine. Although that is subject to whether when you use Zoom, whether cross-examination can also be allowed in that method, or whether the court can be said to watch the demeanor of the witness. But I am I'm not therefore much against the issue of shifting the venue to a more convenient place. That is fair enough. I'm not against the issue of screening of witnesses. That is fair enough. But I'm against the issue of making it look like a secret trial, as if a trial is like a gathering of witches and wizards in a coven. It should be a public trial which the whole world can watch. Then when you come here, you can screen out the people and decide on how many people can attend, the same way we have been doing it. I believe that because of that, by the grace of God, I'm going to challenge some portions of the new practice directions as being unconstitutional and against so many sections of the Constitution of Nigeria, which is the ground norm of the Nigerian law, which are referred to at different fora as the Oba, the Eze, and the Emir of Nigerian laws in the hierarchy of laws, the ground norm, the Fronts Aid, Origo, who will challenge those sections.